Welcome to Weber Gallagher University the series of educational programs. This is our workers' compensation webinar series. I'm Robert Hanneman, and I'm presenting today with Jennifer Labor from our Mount Laurel office. If you would like to visit this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website at www.wglaw.com, and you'll find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is the 20 most common questions related to New Jersey workers' compensation. Let's get started. What we decided was all of these webinars have been usually based on individual topics. We spend about a half an hour or 35 minutes going over one specific topic. Jen and I sat down and thought about what really would the carriers and the clients, the employers, and the adjusters like to hear about. So what we came up with was basically 20 of the most common questions that the attorneys here in our office get from the various parties that we represent, whether it be the employer, whether it be the carrier, whether it be the actual adjuster. So we're going to start. Jen's going to go with question number one.
The first question that we have is, why do we have to set up an exam, an evaluation? In New Jersey, we have the right to control medical treatment. That's one of the most important rights that we get in New Jersey. Most other states don't have that. So since we control medical treatment, it's really important for a carrier and employer to take control of the treatment, because we can control not only the cost for the treatment, but also the a lot of times the length of time. So in New Jersey, a lot of times, one of the things, we don't really have chiropractic treatment. That's something that's done in a lot of other states. In New Jersey, usually they'll see the doctors or the physical therapy, but chiropractic treatment, something like that's not something that takes place. Also, the doctors can control whether or not the treatment is causally related to the accident. So scheduling the evaluation with respected doctor helps keep the treatment in line and in control, and can hopefully get you to MMI at a quicker pace. One of the things that we've seen a lot of times is, if a claim's denied, unauthorized treatment continues ongoing, and there's nothing that you can do. The courts will not, if an individual wants to treat unauthorized and they're responsible for those medical bills and treatment, the court can't tell them that they have to stop. So a lot of times treatment will be ongoing, extensive. There'll be treatment tests that are done that don't need to be done, and there's a lot of times causality gets sort of put into, it becomes a muddied issue when you don't have control over the treatment. So it's something that we really recommend. We feel that it's something that's important. The other issue is that if you refuse to schedule an evaluation, especially in a compensable claim, or in a claim where the issue is medical causation, you'll see a motion for men-in-temp. And when a motion for medical and temporary disability benefits is filed, and there's an issue as to medical treatment, you have to schedule an exam anyway. So I always recommend that if they're going to threaten to file a motion, you really want to address the treatment issue now, because if later on you schedule the evaluation, ultimately it's determined that treatment is related, you then face up to a 20% attorney fee related to all medical treatment and or temporary disability benefits. So this way you can limit your costs with regard to that, and you can have, again, you could pick the doctor. So it's really important to just focus on controlling medical treatment, taking charge since you have that ability. That's really one of the benefits in New Jersey. Rob, the next question?
Sure. It's kind of a compound question. How do you calculate the average weekly wage, temporary disability rate, and the permanent disability rate? In New Jersey, as you know, we get three benefits. We get temporary disability. It's 70% of your gross weekly wage. There's a maximum and minimum per the workers' compensation schedule of disabilities. That's set up each year. It's based on the average income earnings of all of the state employees, not just the state employees, but everybody who works in the state of New Jersey. For temporary disability, there's a 400-week limit. You're paid for all the time you're out of work once you've passed the initial 7-day threshold. Yes, they are responsible for paying for the initial 7 days, but you don't have to pay for that initial 7 days until after petitioner has already passed that 7th day. So petitioner is out the first 2 days and then returns back to work. there's no temporary disability owed. But if petitioner then goes out for another week after that, you do owe those previous 2 days that petitioner was out. There's been a lot of discussion in the courts. Jen and I are laughing about this because we've had this issue come up a bunch about how do you actually calculate the wage. As you can see, the rate is based on what the person was contracted for hire. Weekly wages shall be found by, you multiply the daily wage by the customary number of or working days constituting an ordinary week in the character of the work that's involved with the petitioner. For example, if they're a construction worker and they're paid a salary and they typically work 10-hour days, it's going to be based on 40 or 50 hours automatically. If you have it's slightly different if you have someone who's based on hourly rate. That's based on the customary number of hours a petitioner works in that type of job. The reason why this comes up so often, is that, oh, no, back up.
Well, one of the things that we talk about all the time is, so a lot of times we ask for the 26-week wage.
Right.
Normally, you're using the 26-week, but as Rob had said, if you have someone who is contracted, so you're making the job offer and you say, okay, well, your hours are going to be 40 hours a week, your salary is going to be $15 an hour, so your salary for the year will be X number of dollars. That is there's an expectation that the employee will make that amount per year. And while we understand that sometimes they work overtime, sometimes they work less, they have an expectation. So if their 26 weeks is actually lower because you're not offering them the 40 hours that you had contracted to offer, a lot of times there's an argument that you should be using the contract rate, especially if it's someone that's given a salary type of job offer. So the 26 week was intended for piecemeal work, but the statute specifically says for the daily wage by the customary number of working days constituting an ordinary week in the character of the work involved. So there is an argument for using that contract rate of hire. When counsel makes these types of arguments, it can work for and against them. So sometimes some of their clients will get the benefit. They'll get a higher rate if they argue for the contract rate. But if you have if you have a lot of cases with the same client, so you're a company and you have these contract for hire type of job offers, and you assume, or it's your expectation that they're a salaried employee, a lot of times just let us know what their salary offer is. So what's their hourly rate? How many hours are they supposed to be working an hour? So, or essentially what's their salary per year? And then we can go based upon that, because it's really, the 26-week wage was meant for piecemeal work, and it's not always the appropriate way to go on figuring it out.
Right, but we fall back on that when we don't have all of the information. If you hired someone and said, you're going to work as many hours as we can provide you.
Exactly.
If you have someone who will do a significant amount of overtime as opposed to no overtime, if they work more than their contract hire 40 hours, petitioner's counsel may argue, well, give me the 26 weeks because I know my client is making not only his 40 hours, but he does 15 hours of overtime every single week. And therefore he wants to calculate it based on the 26 weeks. So always provide the 26 weeks, but understand that there's been more push lately about hourly employees, about calculating it, the wages based on what their contract for hire is.
Right. So it's not 26 weeks isn't the be all end all for figuring out the average wage and then the rate. So just keep that in mind. The next issue we get asked all the time, because a lot of the other states have this, does New Jersey have partial temp? And the short answer is no, there's no statutory provision for it. But. However, there was a trial level decision, the case of Soto, that Judge Cox had, there was a trial and a decision by Judge Cox. It's a trial level decision that was not appealed, so it is not binding on anyone. However, every single judge that we've ever asked always is of the same opinion, that if an individual is under authorized treatment and they're returned to work in a limited capacity, so they're returning light duty and they're making less than their temp rate, that is not technically a reasonable job offer, in that you must pay partial temp. So the court in the Soto versus Harris decision had indicated that you need to pay at least the difference between the temp rate less what they were making on light duty. Generally, you can, this is something that there is obviously nothing in the statute, so it is something that can be negotiated. It's something that if you have this situation, let your attorney know. If the petitioner doesn't make any waves about it, doesn't ask you why they're making less money or demands more money, then don't pay any more money. But obviously, it's something that if it's brought to your attention, you need to address it. Reach out to counsel. We can always give you some guidance depending upon, because obviously you'd have to figure it out week by week. There's sometimes you can compromise it. There's nothing specifically in a statute that guarantees it. So it is a negotiable type of situation.
Right. I think the court's going to look at what is fair for the petitioner.
Right.
In the Soto case, the doctor, the authorized treating physician, had recommended that he goes back to work on a light duty capacity, but only work 2 hours a day.
Mm-hmm.
As soon as he went back to work for those 2 hours a day, he was cut off from his temporary disability.
Right.
There was no discussion about whether or not they were going to pay any voluntary tender or make up the difference or anything like that. I don't know if that was part of the negotiations that never made it into the case law or never made it into the decision, but the judge felt it was inherently unreasonable that petitioner would go back to his job and only make, instead of 40 hours a week, he was only doing 10 hours a week and be expected to live on that kind of income. So it really has to do with a reasonableness standard.
Right. So again, usually what's done is you take the difference between the temp rate and what they're paid. So keep that in mind. But again, it's not statutorily something
Mandated,
that
right.
It's mandated.
Question number 4, what is reconstruction of wage and rate, and when can it be used or argued? We hate this. We'll be honest. Reconstruction takes place on permanency. And that's the only time it takes place. If you have an individual who's working less than the normal hours in his position, and the seminal case, as you can see, is Katsoris, in that the judge must consider whether the employee's disability represents a loss of earnings capacity. And that includes not only present but future earning capacity, including the reduction as indicated future. The judge may also consider whether or not the disability reaches into the future and affects the probable future earning capacity and impact on those earnings. If the court will reconstruct a part-time wage to what a person in the normal capacity of that work job duty would be making as a full-time employee.
So keep in mind, though, an example would be a school bus driver. School bus driver does not work 40 hours a week. That's not something
right.
that would happen. They do not. So it's the number of hours worked in that position. Now, the argument can be made that a school bus driver then could go and drive so for New Jersey, they could
right.
drive New Jersey Transit. So then they could potentially work full time. So there's sometimes some wiggle room with regard to that position. So the position being potentially a driver. So a lot of times we've seen the arguments made, but the key first is, are they a part-time employee? So do they work less than full-time? And then that's the first step. And then second is, how does it affect your earning capacity? Are there limitations? What's the injury? What was the treatment done?
Right. That's what Dunkley talks about is the court looks at the nature and extent of the injured employee's restrictions and limitations with regards to a determination of future earnings capacity. One thing you also have to consider is if the position that the petitioner is involved in is actually just a part-time position. Mm-hmm. If there is no full-time position for that type of employee in that area of work, then there is no reconstruction. Counsels argue all the time and say, well, if petitioner was working full duties, but if they were hired to work a part-time job and it's only a part-time job, mm-hmm. there's no reconstruction.
Yeah. The next question we have is, do I have to pay temporary disability benefits if the employee is terminated but on light duty restrictions? There's been a lot of recent case law and arguments. This is something that I just recently had a trial on. And there is a set guidance as to what you should be doing. So temporary disability benefits can be terminated if there was a light duty job offer. So when you make a light duty job offer, a lot of times because you're making it and their expectation is that they can return to work potentially the next day, you want to do it verbally, but you also want to make sure that you document it in writing. Mm-hmm. Copy if they're represented, copy the letter to opposing counsel and your and your representation, but make sure that you follow up and concur whether you left a voicemail or you spoke to them. Send a letter documenting what the job offer is, how much it for, where they're supposed to go, the hours that they're going to work. So document all of that in writing. The position is available. If they do not show up, then you don't have to pay temp. So similar to you cut off temp because you made a light duty offer, their employer then would be paying them at that point. You don't have to pay temp anymore. But the key is, so the Williams versus Topps case, that one, the employer didn't provide the light duty work. So while there was a light duty restrictions, you actually have to make the job offer. If you don't make the job offer, then they can't be expected to not get temporary disability benefits. The other case, Temeki, in that case, the court held that if the employee removes themselves from the labor market, they're not entitled to temporary disability benefits. And then the last case that talks about this that's relevant is Cunningham. And that one, the petitioner not only needs to show that he actually lost income because of his disability to be entitled to temp. So one of the things that you look at is you're given light duty restrictions. A person either says, I'm not showing up, and then you cut them off. A person comes back and shows up to work, but they call out, they leave work, they violate some type of employment policy, and you're going to fire them because of that. You're filing them with cause. You have to make sure that you're firing them for cause. And at that point, they then have that next step where they have to show that they can't get a job because of the disability. Simply because they go out and say, nope, there's no jobs available is not enough.
Right.
They specifically have to be told that they can't get that next job that they're looking for because of light duty restrictions.
Right. The case I had, we required it, petitioner actually produced documentation showing that she tried for 3 different employers, and they actually provided correspondence saying, but for her limitations, it happened to be a leg injury, she would be able to do our job. But because of her leg injury, we can't hire her. The courts found that she had met the burden under Cunningham, that even though she was no longer working with my employer and under our insurance carrier, we weren't paying temp, but now that she's proven she can't get a job someplace else, we had to start temp again.
Right. So that obligation. So simply, if you terminate someone, you don't automatically pick up paying temp again. They have to show you that they can't get a job elsewhere because of the restrictions.
Right. And require in writing.
Right. Right. And let them know that the way you let them know that they're terminated, they've already been advised that they're no longer getting temporary disability benefits. When they try contacting you, if you're the adjuster, you want to just make sure that you say to them, well, you need to provide documentation indicating that you can't get work elsewhere due to your disability. So that's the key with regard to this. There's no guarantee that temp won't be owed if you terminate someone, but you do at least have a chance.
The next question we jump to is, what's the difference between an independent medical examination or what's called an IME, a need for treatment evaluation, and a permanency evaluation? Jen and I are laughing at this because basically they're all basically the same examinations. They're an examination by a physician for a specific purpose. Really, it's the nomenclature or what you call that examination. Defense counsel may have a different way of referring to each of those exams. The vendor that you use to set up those exams may have a different, the carrier may use different verbiage with regards to each of those exams, and the doctor's office themselves will most likely refer to each of them separately, because the doctor's office, as you know, will charge you differently for each different type of exam. The issue is, what does your defense counsel call the exam? And that's what we just talked about. As defense counsel, we usually refer to the need for treatment exam for treatment evaluations. We'll call them NFTs. They may or may not include either the taking over a treatment. It may or may not have reference to permanency evaluations. The vendor tends to call all evaluations IMEs. There's usually no distinction between whether it's a permanency evaluation, need for treatment examination, or a causation report. When we run into the problem is the carrier and the vendor dealing with the doctor's office. They'll often refer to the IMEs as need for treatment evaluations. The need for treatment evaluation with the idea of either taking over care, making an opinion with regards to causal relationship, or they'll call the IME a permanency evaluation. And they charge different rates for each of those different evaluations. And we run into a problem with that. So you need to be specific as to what you are looking for with regards to a case.
Yeah, I mean, it's really important. If you want a permanency evaluation, you're addressing only permanency.
Right.
You're not, and a permanency evaluation, you're asking for the permanency estimate. There are times where you do not necessarily want the doctor to address causation because you've already had a treating doctor address causation.
Right.
But the question is, regardless of cause, what would be the estimate of permanent disability? So if you were to lose a trial on the aspect of causation, you still need an estimate of permanent disability.
Right.
So sometimes you just want a permanency evaluation where they address permanency only. Sometimes you want them to address both causation and the estimate of permanency.
Right. One of the things you need to make sure is you make sure the doctor understands what type of exam you're asking for. Usually when you talk with their scheduling office, they'll ask, is this an IME? The answer is yes, but what type of IME is it? Is it a need for treatment exam? Is it just a causation report, or is it for permanency? You need to make sure it's clear to them, one, because you don't want to have them come back and say, oh, well, we thought this was permanency, so we estimated permanency when it was really a need for treatment exam. You don't want to have a need for treatment exam and an opinion that petitioner needs treatment if you were looking for a permanency evaluation. So,
and it's also, if you want the doctor to take over care, there are a lot of doctors who will evaluate, but if they're asked to address causation, they will not, because they think that there's potentially a conflict of interest. They do not want to be the doctor to take over care. Sometimes that's problematic because then you have a doctor who is evaluating and makes a recommendation, and then you can't find another doctor to take over to provide the treatment that's recommended. So a lot of times if you're looking for a treatment exam, make sure the doctor at least will agree to take over care. You may not want them to, but you want to make sure that they'll at least agree to take over care if requested.
Right.
You also have, with regard to when getting in the reports from doctors, review them. Review what you've asked of them in the initial document. When we get these reports, we look and say, okay, what were we looking for and what did they answer? Did they answer the questions that were asked? If this is a perm exam, did they give a permanency estimate? Did they require anything else? So it's really not only making sure that you're scheduling it right, that you have it documented in writing what you're looking for, but that when you get the report and that it answers the questions that are asked.
Right, and addresses the right body parts.
Yes.
If you're asking for a left shoulder evaluation and they come back with a right shoulder evaluation, you need to make sure that the doctor amends that report to provide you the correct information.
The next question is, what obligation does the adjuster have to speak with the petitioner when they call?
We get this a lot.
Yeah. A lot of times a petitioner will call, and if you want to speak to them, you're absolutely entitled to speak to them. A lot of times they're calling about a lack of payment, a lack of response, something about the doctors with regard to treatment. You can talk to them. If they're represented, you need to tell them that they need to reach out to their attorney and to have their attorney contact defense counsel. A lot of times that makes it easier and cleaner. If it's with regard to scheduling an appointment, then yes, you can absolutely speak to the petitioner about scheduling an appointment, but any specific discussions about the claim itself, it's really sensitive ground. It's not something that I would suggest you doing. So if it's about an appointment, it's just about a scheduling conflict or about something related to that, needing transportation, or if it's needing an interpreter or confirming the doctor's address, yes, absolutely answer their question. But anything more than that, a lot of times you just want to let them know that they're represented and that they should be contacting their attorney.
Right. Also let your defense counsel know if you've been contacted by the petitioner and how frequently. If petitioner calls you 3 times a week about their case, at some point you can tell them you don't want to talk to them anymore and they would rather go through their attorneys and let the attorneys deal with the situation. But again, this all pertains, the first part of that all pertains to you talking to the petitioner if the petitioner calls you.
Right. You cannot call a petitioner if they are represented. You can call the attorney, and the attorney can give you permission to contact the petitioner or to allow the vendor to contact the petitioner with regard to scheduling appointments. Sometimes there are attorneys who will allow no contact. So every appointment notice, every scheduling issue has to be done through counsel. So keep in mind that you do need, even for scheduling appointments, you do need permission to contact the petitioner if they're represented. Now, with regard to an employer can contact the employee about the light duty job offer. So again, we talked before about the fact of what type of making sure that any verbal job offer is followed up in writing. The writing document would be sent to their attorney. So you want to make sure that you copy both your representative and the petitioner's attorney as well. But you can talk to them with regard to making a light duty job offer. The next question sort of goes along with that is, what obligation does an adjuster have to communicate with a family member or a parent? You don't have to talk to them at all. Now, if you're dealing with someone who's incompetent or a minor, then that's a different circumstance. You would obviously need to contact the parent or legal guardian, not the minor child, or if they're incompetent, you would need to contact whoever their legal guardian would be. If written permission is given by the petitioner to speak to a spouse or to speak to another family member, you are allowed to communicate with them, but you don't have to. You can communicate, obviously, if they're represented with their attorney, but a lot of times if someone's wife is calling you to talk about the claim, you do not have to talk to them. And actually, you shouldn't be talking to them about a claim where they're not the injured employee unless you get written permission from the actual injured employee. Right. So keep that in mind. You don't want to get into any HIPAA violations or issues with that. A lot of times we know it's difficult to get written permission, but it's something that, especially if they're represented by counsel, we can always assist in getting permission for you to speak or notify them about appointments if that's the easiest way to go about doing it.
And we understand how frustrated you will get sometimes when you get family members that call repeatedly on behalf of the injured employee. They want to know what's going on. Either maybe the injured employee hasn't been in contact with their counsel, or their counsel hasn't been in contact with them. And so they're trying to go around that relationship and try to get more information from you. Keep in mind, you don't have to, and you shouldn't be given a non-legal guardian or a non-parent any information about someone's injuries in their case. Transportation. Everybody just loves this question. Why do we have to provide transportation to a petitioner? In a situation where the petitioner cannot drive, then transportation has been considered reasonable and necessary. There's a Squeo case that talks about providing reasonable and necessary medical benefits. Transportation in some instances is considered part of that treatment if petitioner has no possibility of being able to get to the authorized treating physician because of the limitations related to the work injury.
Well, and that's one of the things that's really key. So if the person can't get to the transportation because they have a foot injury and that's their driving foot, that would make sense, or they just had surgery. But if they can't get to it for financial reasons, is that, a lot of times for financial, you want them to be able to receive the treatment. Sometimes you consider making some type of voluntary offer or payment with regard to it. It used to be because of voluntary tenders and the benefits that you used to get, it'd be something you would consider before doing. Now, not necessarily as much. It's something that you want to talk to counsel about those issues if it's a financial consideration.
It really comes down to, again, the standard for reasonableness. What's the court going to think is reasonable under the circumstances? In New Jersey, we have treating physicians all throughout the state. There's orthopedics in both South Jersey and North Jersey. There's psychiatric evaluators in South Jersey and North Jersey. Not so many in South Jersey, but and pain management all throughout the state. So we can find some treating physician within an hour of the petitioner's place of residence. The courts have deemed previously that driving 1 hour usually isn't too far to go for someone with regards to treatment. On the other hand, if you live in South Jersey and require someone to drive all the way up to North Jersey for an orthopedic evaluation or even just physical therapy 3 or 4 times a week, driving an hour and a half or 2 hours one way just to go for medical treatment, the court's going to think that might be unreasonable and want you to move the doctor to someplace closer, or they're going to require you to provide the transportation so there's less impact on the petitioner. Also, if the hardship issue, as Jen has already talked about, we make mention that there's more ways to get a petitioner from point A to point B now. Instead of just paying for a car service, it may be that you might want to have them open up an Uber account and reimburse them for that, or try to take the bus and subway. It all depends on what's considered reasonable. I get the next one also. When and how often can we change doctors, facilities, and providers? We get this question a lot. If you're not happy with the physicians and the way the treatment's going, what can we do? Typically, you can't just shop for another doctor. If we authorize a treating physician, the court says under the statute, you've picked that doctor, you're going to be bound by his determinations. Under the statute, it kind of gives you a little bit of an out also. Under NJSA 34:15-19, the carrier always has the right to get an independent medical examination anytime during the treatment to see if the treatment that's being provided is still reasonable and necessary. If you just had an examination and you don't like the doctor's opinion and you go and shoot for a second IME to try to get another opinion, the court's going to have a problem with that. If petitioner has been treating for several weeks or several months and the treatment seems to be static over that period of time, the doctor's filling out the same report, the same information, the same injuries, the same complaints, and all they're doing is upgrading the medication, you may want to get an IME and at that point and have a doctor evaluate to see if that treatment is still reasonable and necessary, or if petitioner has reached a palliative place where we can move forward towards permanency. The court's going to look at your intent. Is it being done just to end the treatment? If so, most likely the court's not going to accept that second report. If it's being done to address a reasonable need for clarity with regards to the issue, the court's always going to give willing to give consideration to it, regardless of what petitioner's counsel is going to say, because you're going to hear the other side say every examination that's done and an IME when petitioner is getting treatment must be, we're trying to cut petitioner off from treatment, we're trying to stop it, we're just trying to get out of our responsibilities, and that's not necessarily true.
And the key is the type of doctor you're using. So if this petitioner has been treating for an extensive period of time with the doctor and there's no improvement, sending an IME evaluation, and in this term we say IME because when you schedule it, if you're sending a referral for a scheduling company, you say please schedule an IME. A lot of times they use the doctors that are the same doctors that do the permanency evaluations. And the court's not going to consider that doctor to be a credible doctor compared to this other doctor who's been treating the petitioner for an extensive period of time. You need to have an equally qualified doctor who normally provides treatment, evaluating and offering either different solutions, recommendations, or at least indicating that the treatment is palliative at this point. So making sure that if you're going to try and change the treating doctor, you're absolutely able to do that. And it's something that at times we definitely recommend, but the type of evaluation you schedule and who you schedule it with is really important. It's something you should discuss with counsel and come up with an alternative possibility. The next question that we have is, why is a petitioner entitled to any permanency if they finish treatment, return to the same job without restrictions? In New Jersey, we have the Perez standard, which requires a lessening to a material degree of not only your working ability, but also the ordinary pursuits of life. And that constitutes permanent disability. So you may have someone who goes back to work full duty, no restrictions, but at home there's things that they can't do. So someone who used to like horseback riding, but they have a back injury, they can return potentially to work full time, but they can no longer ride a horse because of the pain that's caused with their back. So that in and of itself would also constitute permanency. So you have to look at how the injury affects the petitioner overall.
And it's specific for each individual.
Right.
I don't mean to jump in, but the one I have is the petitioner, young individual was a bodybuilder. Mm-hmm. And this individual lifts 400 pounds on a regular basis in the gym. He suffered a shoulder injury. After treatment, he went back to work full duties, no restrictions, doing the same job duties, same responsibilities, and went back to the gym, but he could only bench press 250 pounds. I don't know about anybody listening to this, but I can't touch 250 pounds. Okay, so even that, the court found that because his restrictions prevented him from doing exactly what he was doing before, they still found permanent disability.
So, and keep in mind, when your expert finds no permanent disability, it gives you a basis for Section 20. So if our expert says no permanent disability, their expert has an estimate of permanency, you can, New Jersey, that's one of the bases for Section 20. So you can then resolve the matter in that manner, which then would preclude reopener, which is one of the things you would look to do. So in this instance, if there's that dispute, many times the court will recommend a Section 20 resolution. They're not just going to dismiss the claim entirely unless it has to proceed with trial. But generally, the courts want some type of resolution, whether it be a Section 20 or a permanency payment.
The next question has to do with treatment. And when petitioner has filed a motion and there's been an order entered against us and we've provided treatment, what is the fee on the motion for med and temp? What's it based on and why? Pursuant to the statute, the court has established that the fee can be up to 20% of the award for a motion for medical treatment, and it's based on the benefits provided. That includes temporary disability as well as the medical benefits as the result of the motion. So we argue continuously, depending on how long a motion takes, from the date of the court order going forward, that's when we argue the benefits begin to run. That's subject to the fee calculation.
And sometimes if the motion was only with regard to an element of treatment, so if it was only with regard to getting one diagnostic done, a lot of times after the diagnostic is done, you'd like to close out the motion and address the fee at that point. Or if it's only with regard to treatment, but you've already been still paying temporary disability benefits, you're not going to pay a fee on the temp that you were already paying. You're only going to pay a fee on the treatment that was provided as a result of the motion. So you have to look at what the motion was filed for and then the treatment and or benefits that were provided as a result of the motion.
Right. You'll get a request from defense counsel asking for your payment ledgers, and typically they come all inclusive. They'll include things such as your defense attorney bills, the permanency evaluation costs, a bill review or administrative costs that are done as part of handling the treatment. Those should be excluded. And you should review that with your defense counsel as to what they think should be included and excluded. Typically, it's my practice that I don't just send that payment ledger to petitioner's counsel. I go through it and I deduct whatever I think should be excluded from that. And then I tell counsel what I think the total dollar figure is. And then again, we try to negotiate fees with regards to this. The statute provides that the court has it's solely within the discretion of the judge to determine what's a reasonable fee with regards to resolution of the case. That applies to permanency as well as the motions.
Right.
Some judges feel that if you file the motion, you get a 20% fee. There's no arguments, no discussions. That's all it is. That's all there ever will be. There's only a few judges that I think still hold to that philosophy. Most judges will allow the parties to negotiate a resolution. I'm lucky enough that down in Atlantic City, where we deal with these cases, unless there was testimony of the party, the court will almost always allow us to negotiate a fee less than 20%. If there was testimony, the court feels that was a much more contested motion, there was much more activities required, and counsel had to do more to get the benefits for his client, and therefore should be entitled to the higher fee.
And sometimes it depends on the amount. So if there was little effort with regard to the motion, but the treatment, let's say, totals $250,000, the court's going to take a look at what the actual motion was, what the efforts were done, and depending upon the amount, it's something that you, if you feel it's unjust, you can argue it, and it's something that after our arguments are made on the record, the court then would render their decision. If it's something that's negotiated, then it doesn't have to be done on the record. Right. The judge still has to approve it, but that approval generally, if both parties agree to it, the judge will generally approve it. And the next question is, if the petitioner is still treating and chooses to move out of state, are we still responsible for providing treatment? So I get asked this question a lot, and a lot of times it depends. It depends on where you are in the stage of treatment. So if this is a reopener and a person has now moved, let's say an individual has moved to Florida and they used to be in New Jersey and they've reopened and they say, I'd like to go back for treatment. In a reopener, always I suggest scheduling the initial evaluation in New Jersey, saying, listen, we understand you moved. You need to come up here, have the initial appointment up here so that the doctor who understands New Jersey standards and understands New Jersey workman's compensation claims can determine whether or not you need treatment related, reasonable, and necessary. And if the doctor then finds the treatment is reasonable, necessary, related, then we would transfer the treatment down to where you live in Florida. So it's something that you can't obviously require them to stay in New Jersey for treatment, right. But a lot of times you can require them to come back up to New Jersey. If it is someone who has been receiving treatment all along and they're looking to move, you want to try and make sure that there's a smooth transition so that hopefully they've given you enough ample notice to let you know that they're moving. And this way you can find and transfer treatment based upon the recommendations of the treating doctor to a location in that area. If you do not have any understanding of the doctors in that location, sometimes, obviously we know doctors in New Jersey, but we don't know doctors let's say in the state of Texas. So I can't tell you what doctors to use, and you don't have a vendor that can let you know of a doctor in that state, or you have no doctors that you're aware of. You can then ask the petitioner to find a doctor that's close by to them that they would like to treat with. So that is an option. It's not something we would like to do, but it is definitely something, as long as the doctor's agreeable to taking New Jersey workman's comp. That's one of the problems that you a lot of times have, is that the doctors are unwilling to accept that it's a New Jersey workman's comp. They don't want to address the standards, or they don't want to accept the fee payment based upon New Jersey. That's something that you would have to negotiate and discuss with the doctor. So keep that in mind. But petitioner who moves, they're allowed to move, and they're allowed to seek treatment where they move. But definitely making sure that the New Jersey doctor gives guidance. And if you periodically need them to come back to New Jersey, that also is permissible. And for a perm exam, they must come back to New Jersey to have the perm exam. That there is no question of that.
Right.
And you're not responsible for paying for them to come back too. So keep that in mind.
Right. Keep in mind also that an out-of-state doctor may not understand the idea of maximum medical improvement that we focus on in New Jersey. You want to keep a closer watch on those kind of cases where you're providing authorized treatment out of state. You want to make sure you follow up with the doctors on a regular basis to get the medical records. You need to know what's going on and what's being provided. And if you think if we think we're running into that period where the treatment is getting static and it's just seems to be rolling over the same thing every month, that's when we can schedule an IME here in New Jersey and get an address as to whether or not treatment's still reasonable and or necessary. It goes to me, right? Yep. What is meant by accrual of benefits when paying permanency award, and how is it calculated? We get this a lot also. You've had a petitioner who had a compensable injury, received authorized treatment, completed the treatment, returned back to work, you ended temporary disability, and there's no outstanding issues there. We've got exams, and now we're ready to determine permanency. We've negotiated a percentage of disability, but what is owed to the petitioner? Petitioner is entitled to the payments for any award of permanency that begins on the last day of temporary disability. From the last date of temporary disability, we calculate how much time has accrued from the day after the last date of temp until the award is entered, and that's how much the petitioner is owed at the time of the settlement. It could all be accrued. It could have been that for whatever reason it took a year plus to get all the exams done and all the information, and the award's not that significant, that there's less than 52 weeks of an award being paid, and therefore it is all accrued with regards to the benefits. Most of the time, when you have larger awards, it's not all accrued. So what defense counsel will ask you for is, when was the last date of temporary disability paid? Provide that to your defense counsel, and when they provide you with the settlement documents, they can calculate, this is how much based on my estimate that is owed to the petitioner, and then we have to pay out the rest of the award in the weekly benefits going into the future.
Mm-hmm. And the reason it's important is because obviously not only with regard to the payments, but the statute of limitations goes based upon that last payment, because usually in this type of situation, there's not additional ongoing medical treatment. Right.
There's two exceptions though. The first one has to do with Owens. If you have a third-party settlement, or the third party has already resolved, what you can do is, under the Owens decision, you can pay the permanency benefits in a lump sum rather than paying them over weekly, because you may be receiving a credit based on your Section 40 lien rights, and you may be paying that permanency award at a rate of 1/3. You can accelerate all those payments so that there's no issue with regards to how much am I keep paying, how much is my credit, how much is going forward on this, what do I do? So you can, under Owens, you can accelerate all the payments and pay out that permanency award, even if he was entitled to another 150 weeks of benefits.
And the reason you're supposed to do that is because obviously you're going to continue taking the deductions on the medical. So this way you know exactly what the deductions are at that point, and this way you now know what your remaining Section 40 lien rights are ongoing, if any.
This doesn't change the statute of limitations, though. You'd still have to calculate when his actual benefit would have last been paid, and then it's 2 years from that last date. So it doesn't change the statute of limitations. The other exemption has to do with total disability. Total disability is paid from the date of totality. That may or may not be the last date of temporary disability. Petitioner's counsel will almost always argue that the last date of temp should be the date of totality. That's not always correct. Most of the time it is calculated based on when a determination was made that petitioner is totally and permanently disabled. There has to be a assuming there's a second injury fund case, I didn't write that in there, but assuming there's a second injury fund case, When the fund application is filed, they have to have a report of totality attached to that. It's usually the date on that report that's given consideration for date of totality. This is usually a negotiated time period. It can actually be just a hypothetical date that's agreed to by all the parties, and the court agrees that this is the date of totality. A lot of times when you're arguing with the second injury fund and they're paying a significant portion, 30, 40, or 50% of it, they want the date to be closest to today's date, because then the fund doesn't become eligible to pay their benefits till sometime way in the future.
Right.
We want to argue that it should be a year or two ago. Then when we pay our benefits, the fund comes on much quicker. We get rid of our benefits. All we're responsible in the total case is for future medicals, but there's no more financial money coming out for permanency.
Right.
I get to do the next one. Is taking a walk in a multi-tenant parking lot while on a paid break with the approval of your employer compensable? Our position with this is no. If the employee leaves the employer's premise, then the injury would not be work-related. There's provisos with that. However, if you need to evaluate under the premises test, it's where the injury occurs if it's within the control of the employer. In our hypothetical question, if you have a multi-tenant building and your employer controls the parking lot and is responsible for cleaning the sidewalks and clearing the parking lot, and he hired the service that does that, then that entire area is considered the premise for your employer. And if you're walking around that building and fall in that parking lot, most likely the court would find that to be a compensable injury. If you're in a multi-tenant building and there's only one way in or out of that building, and you fall going in and out of the building and the only access to it, another court would most likely find that also to be compensable. If there's several different entries to the building and you choose one over the other, the court's probably not going to find that compensable until you reach where your office is located. If you fall in the lobby of a multi-tenant building and your office is located on the 3rd floor, and there's several avenues you could have went to get to that front door of your office, most likely that's not compensable because it would still be considered part of the non-controlled area. It really has to do with what does your employer control. Now, there's a whole bunch of cases. We didn't put any of the cases in here. There's a whole bunch of cases about what does control mean, and does your employer, is it control if your employer tells you not to park someplace and park someplace else, if they tell you use a specific set of stairs, if they a specific elevator. So there's a whole bunch of different cases on that.
The key with this is don't automatically accept the case if just because you told your employee, yeah, you can go get a cup of coffee downstairs at the Starbucks downstairs. Right. If you're in a multi-tenant building and you tell them to go down and get coffee, that's not automatically compensable. It's really something that it's case specific. It's usually very case specific, and there's no guarantee. So a lot of times, do not just accept the case. Call us. That's what we're here for. The next question is a contract signed by employee or petitioner that they are an independent contractor and not entitled to workers' comp enforceable? No, not usually. Not only that, but just because someone is considered an independent contractor for tax purposes, many times that same individual for workers' comp is not considered an independent contractor. So you have to evaluate this using the relative nature of the work test and the control test. So the answer is these types of agreements really have no bearing on workman's comp. So if you categorize someone as an independent contractor, you need to determine whether or not they're entitled to workman's comp, and there's specific cases that you go through. If this is something as an employer, you categorize everyone as an independent contractor and you want to know whether in fact they are, contact us. We can help you, give you some guidance depending upon what they're doing. If you give us specific guidelines, we can let you know whether or not the court would normally find them to be an independent contractor or an employee under workman's comp. More often than not, though, they are considered to be an employee. The court tries to make them to be an employee, especially if there's no alternative case, whether it be a liability claim or if there's no alternative coverage for them. They will try and make it a workers' comp case. And a lot of times it depends on the extent of the injury. So just keep that in mind. The next question is, are illegal aliens entitled to comp? Yes. There's no bar to New Jersey workers' comp. They're still entitled to temp, to treatment. They're entitled to perm. They're not going to be hauled away if they file a workers' comp claim. There are protections that the court puts in place. Generally, you'll know that they're an illegal if they are assigned a 900 number on the claim petition. So you do want to keep in mind as an employer, if they gave you a a Social Security card, and they showed that they were a legal resident of the country. You do want to look, though, to see on the claim petition what the Social Security number that was assigned and if that's the same one that they gave you, because you may have some employment issues separate and apart from workman's comp. So just keep that in mind as well. But yes, they're absolutely entitled to workman's comp.
We decided to throw this question in there, but we made it very narrow because we could spend an entire seminar on talking about MSAs and Medicare. Do you need an MSA when you're settling a case versus OAS? And when we refer to OAS, Medicare, MSA is a Medicare set-aside, OAS is an order approving settlement. That's where you get a percentage of disability. The answer is no. The only time the Medicare set-aside is necessary is when the settlement is terminating all future medical benefits with regards to this claim. In New Jersey, we call those a Section 20. That's the provision of the statute that allows us to do it. It dismisses the claim and allows us to pay a settlement for the value of the claim, and it terminates all future benefits with regards to that, including medical. Because of that, that's the only time an MSA is required. MSA's got a couple provisions with regards to when you're supposed to write for an MSA or do a proposal. There's a $25,000 threshold. Just because there's a threshold doesn't mean you don't necessarily need to do an MSA, but as long as you've, quote, taken Medicare's interest into consideration, you'll hear that language every day when you talk about Medicare stuff. As long as you've taken Medicare's interest into consideration and you note that in the settlement, you should be protected if it's under $25,000. But if you have to write away for an MSA, then it's only with regards to Section 20s. OAS, you don't need it.
Okay.
I get the next one. Cool. If the petitioner falls due to an idiopathic condition, idiopathic means it was something that just happened, seizure, stroke. All of a sudden, petitioner gets lightheaded and falls down. Are the injuries sustained compensable? If they are, why and why not? With regards to the idiopathic injuries, the compensable nature is what happened to the petitioner as a result of the fall. The fall in and of itself and the underlying condition is not compensable. If you have an underlying seizure disorder, you have epilepsy, and I only use that because it's an easy example, or you have some other condition that causes you to suffer an injury or a fall of this nature, it's not that condition that's compensable. But if as a result of the fall, you hit your head or your shoulder on the desk on your way down and dislocate your shoulder or fracture your cheekbone, that part of the injury is compensable, and that's part of the workers' compensation claim.
The last question we have is, can you assert a lien if you settle under Section 20? Yes. However, you must document it on the settlement order. Normally, it's considered waived if it's not documented in the order. It's something that should be put on the order and on the record. As long as it's on one of the two, you're protected, but it's something that should be protected and considered it's part of the negotiation tactics. So just keep that in mind. Thank you again for attending our webinar, the 20 most common questions related to New Jersey workmen's compensation. You can learn more about this program and all other Weber Gallagher events by visiting our website at wglaw.com. Thank you very much. And if you have any questions about any other topics that we didn't address, feel free to email questions at wglaw.com, or you can contact either Rob and I directly with any questions, or if you want to know more about anything that we discussed today. Thank you.
Hopefully we answered your questions.